AFSA, Armed Forces Special Powers Act, AFSPA. Just we will see the brief outline about it and what is the status of current provisions of the act. First, let us see when it was enacted. It was enacted on September 11th, 1958. If you see, the purpose of the enactment of the AFSA is it was implemented to address the insurgency, especially in the northeastern areas, especially in the northeastern states of the Assam and Manipur. So the main aim of the act, which was enacted in 1958, is to address the insurgency issues in the northeastern states of India, particularly in the Assam and Manipur. Over time, its scope was extended to other parts of the northeastern and also Jammu and Kashmir to manage the unrest and insurgencies in those areas. And we will see what is the aim of the creation of this AFSA. So actually this act is enabling Indian armed forces, which means that which includes both paramilitary and military forces both together. So it allows the Indian armed forces to act decisively in areas that are facing internal disturbances. Now we have to see for what areas it is going to apply. It will apply to the internal disturbance areas, and it will applicable for the insurgency areas, and also where there is a armed rebellion we can use the act. But the question here is, what is the progressive definition of internal disturbances and the definition of insurgency, definition of armed rebellion? All these are generally indicatory in nature, which means that there is no standard definition for these words. So according to the situation, the concerned people can interpret these they can interpret these words to any context, and they are going to apply. So it will enable the Indian armed forces to act decisively in areas that are facing internal disturbances, insurgency or armed rebellion. And also it provides the legal cover for the use of the force. So which means that when the armed forces is taking any action in the name of the internal disturbance or in the name of the insurgency or in the name of the armed rebellion, whatever the actions taken by the armed forces, they are not legally binding, which means that whatever the actions done by them, based on those actions we cannot prosecute them in the Indian judiciary perspective. So this is applicable once the state or central government is declaring an area as a internal disturbance area, or there is a possibility for insurgency, or there is a possibility for the armed rebellion. So once any area is dedicated, and if it is bring into the purview of the AFSA Act, the armed forces have full powers to act decisively according to their intention. So now we can see what are the objectives of the AFSA. So generally, according to the act which is enacted in 1958, the objective of the AFSA is to restore peace, maintain law and order, and safeguard national security. So according to the law, we have to see the AFSA is aimed to get the peace in the disturbed areas and also to maintain law and order in the disturbed areas and also to safeguard the national security. These three are the primary objectives. To achieve these objectives, it allows the military intervention when required in regions affected by the insurgency or extremism or terrorism. So the law provides a special powers to the armed forces to arrest individuals, search properties, and also to use force to counter the insurgency or other form of the violent disturbances. Now we can see who is the authorized person to declare any area as a disturbed area. Generally, the power rests with three people. Either the central government can declare, or a state government can declare, or a governor also can declare any area is a disturbed area, and they can impose Armed Forces Special Provision Act in those areas. So the central government can declare an area as a disturbed area under the Armed Forces Special Provision Act. Even the state government also has the power to make such a declaration. And in the states, actually, when the government is not in a position to take a decision, in his discretion, even a governor can declare an area as a disturbed area. So once the declaration was done, those areas comes under the purview of the AFSA, and it gives the decisive powers to the armed forces to act on their own discretion without having any legal bindings. That is the important thing. Then we can see that what are the criteria. So if we can see that what are the criteria to declare any area as a disturbed area, which is the area which is to be declared under the AFSA. So we should have broadly three criteria are there, and these three criteria are indicative in nature. Maybe the list is exhaustive, but based on the Special Provision Act 1958, which is act done by the Parliament of India, there are three main criteria should be there. Number one, it should be an existence of the insurgency should be there. So the area should have a history of the insurgency or ongoing insurgency, or the area has a history of the armed rebellion, and there is a high possibility of the armed rebellion in future. If these two conditions are met, then they can consider and they can declare an area as a disturbed area, and so that they can apply the Armed Forces Special Provision Act. And the second thing is internal disturbances, which means that within the state, if any area is or fighting for their own cause, for example, you can take in some of the states, they are asking for the statehood. They want to separate from their own state and they want to create a new state, and they are doing a lot of disturbance to the public law and order. So if those kind of the internal disturbances are there, even that is also one of the criteria. And third most important is the cross-border terrorism. So wherever the cross-border terrorism is there, and if the history is there, and even if they have a doubt that there might be a possibility for the cross-border terrorism, even they have right to declare that area as a disturbed area. Now we will see that the important provisions under the Armed Forces Special Provision Act. We can see that the important provisions. The first and foremost is the first and foremost provision is power to use force. Power to use force. So under the Armed Forces Special Provision Act, the military or paramilitary forces have the authority to use the force, including right to shoot and kill anyone involved in the armed rebellion. This is the most controversial provision because it is giving an opportunity for them even to shoot them. After shooting, you are not even responsible or liable in the eyes of the Indian judiciary. So the armed forces have the authority to use the force, including right to shoot and kill anyone involved in the armed rebellion or violence. This power is applicable even if the person is not directly involved in the armed conflict but is suspected of being threat. So this is to be controversial. Even if there is a suspect, even if he is a suspect, then still they have power to use the force, even they have a power to shoot that person also. And the second and important provision is power of arrest, and also power to search the premises. So whatever the paramilitary or armed forces which are deployed in that area, they are authorized to arrest individuals and also conduct searches without a warrant. So warrant is not required even to search the premises. So, and also they can detain any individuals up to 90 days. They can detain any individual up to 90 days without formal charges being filed. The third important provision is protection what they have, what they're enjoying. So what is the protection is any action taken by the armed forces personnel under this act cannot be challenged in court unless the central government authorizes such legal proceedings. So when the central government is declaring an area under the AFSA, obviously the central government will not authorize any court to see and to initiate proceedings against these armed people. So which means that this grants an immunity to the armed people. So it will provide an immunity to the military personnel from prosecution or civil suits for actions carried out during the operations of the AFSA. And one more important provision is disturbed area declaration. Disturbed area declaration. As we already said, even the state or central government or even the governor has right to declare any area as a disturbed area, providing the legal basis invoking the AFSA in that region. So this declaration normally has to reviewed periodically. In the review, if the any of the authority who has right to declare any area as the disturbed area under this act, they have to review this periodically, and whenever the situation is normal, they have to remove that area from this special provision act. Now if we can see the historical background and the development of this one, we will see the historical background of this bill. So we know that initially it was enacted in the 1958 to deal with the insurgency in the northeastern states, particularly in the Nagaland, and also it was applied to the Manipur, Assam, and later extended to the northeastern states also. And for the first time in Jammu and Kashmir, they imposed Armed Forces Special Provision Act in 1990 following the insurgency in the region. So it was seen as a way to control the militancy and restore the normalcy. And over the time, the AFSA has been extended to other conflict zones. Even we implemented AFSA Act even in Chhattisgarh also. And because it is a Maoist affected area, to curb the left-wing extremism, they imposed. And most of the northeastern states, even the Manipur, Assam, Mizoram, Tripura, in some of the areas, according to the situation, sometimes this Armed Forces Special Provision Act was implemented. But generally the Supreme Court clearly says that there is a need to review periodically, and whenever the situation becomes normal, they have to revoke the application of that act for that region. And if you can see the current status of the AFSPA, which is in 2024, if you can see the status, it is implemented in the Jammu and Kashmir region. So it remains force in Jammu and Kashmir from 1990 itself, but over a period of time, some of the parts of the region was removed from the AFSA because there is a gradual relaxation is there, because there is a security improvement is there. So whenever there is an improvement in the security, in which area, based on the areas which having a good security, then they removed those areas under the AFSA provisions, and remaining other areas are still under the AFSA provision. In northeastern state, currently it is there in Nagaland, Assam and Manipur, although its imposition in certain regions has been relaxed in recent years due to the improvement again in the security situation. Now we can see what are the important Supreme Court observations on Armed Forces Special Provision Act. We have a case called Naga People's Movement. The case is Naga People Movement of Human Rights versus Union of India, 1997. So in this landmark case, the Supreme Court addressed the constitutional validity of the Armed Forces Special Provision Act and its application in the northeastern states, particularly in Nagaland. So the petitioners challenged the imposition of AFSA in Nagaland, claiming it violated their fundamental rights under Article number 14, which is right to equality, Article number 19, which is freedom of speech and expression, and also under Article number 21, that is right to life and personal liberty. So because we know that when area is declared under the Armed Forces Special Provision Act, obviously the people living in that area are going to lose these rights. So Article 14, which is right to equality, Article 19 and also Article 21. So during this case, actually, the Supreme Court upheld the constitutional validity of the Armed Forces Special Provision Act. The Supreme Court says that constitutionally this act is valid, but stating that the law is necessary for dealing with situations of the armed rebellion or insurgency only. The court also emphasized that disturbed area notification must be given serious consideration, but it did not provide any definitive solution on the excessive use of the force under the law. So by that time, the Supreme Court says that yes, constitutional validity is there for the Armed Forces Special Provision Act, but only thing they clearly told was even though it is constitutionally valid, whenever you are making any notification about any area as a disturbed area, we have to consider that matter as a serious consideration, and by considering all the situations on the ground, then only the respective authority has to take a call whether we have to impose the area under the Armed Forces Special Provision or not. And again, in 2012, we have one more important case. So the case is about the People's Union for Civil Liberties. The People's Union for Civil Liberties versus Union of India. So this case was heard in 2012. So this case revolved around the allegations of the human rights abuses under the Armed Forces Special Provision Act in Manipur, especially the case of the extrajudicial killings. Because we know that the Manipur is not only now, even in 2012, it is a very disturbed state due to large number of tribes are available over there, and also the disturbances between the mainstream community and the tribal community is always having conflict existing between the mainstream and the tribal communities. So the petitioners argued that the powers granted under the Armed Forces Special Provision Act, which led to the extrajudicial killings, rape, and also other human rights violation in Manipur. The Supreme Court actually, in a historic judgment, they observed that the Armed Forces Special Provision Act provides the military with excessive powers which could lead to the abuse of the human rights. So for the first time, the Supreme Court admitted, at least it can admitted that excessive powers to the armed people in the name of this act normally, so which lead to the abuse of the human rights, but it can made only a comment, but it cannot declare it is an unconstitutional. It was not declared it is an unconstitutional. It says that implementation of AFSPA should be case by case, and the court clearly emphasized the importance of the accountability and transparency in the military operations, and also suggested that the armed forces must act within the bounds of the law. So the Supreme Court also ordered the formation of an independent inquiry commission to look into the cases of the extrajudicial killings under the Armed Forces Special Provision Act. The court also recommended the creation of the safeguards to prevent misuse, including the necessity of the prior authorization from the government before initiating military operations against civilians. So previously, the armed forces straight away they can take any area under their consideration in the name of the Armed Forces Special Provision Act. Then Supreme Court clearly says that you please take an authorization from the day of the government before they are initiating any military operations against the civilians. And the court is also asking for the transparency, and also the court is asking about the accountability in the military operations. But here the question is, even though it is nice to hear, but what are the original implications on the ground level? It is still in the question mark, because for this case actually they put an inquiry commission, right? So but in many places the Armed Forces Special Provision Act is there. In every place the army has absolute rights to control the territory, to restrict the movement of the people, to restrict the fundamental rights like right to equality and freedom of speech and expression. In those areas, we don't know what is the status of whether the commissions are there or not. But only in this particular case only, the Supreme Court actually initiated an inquiry commission into it. So it asks the government and military people to maintain the transparency and accountability. But in my point of view, the question here is asking is not suffice. So because once there is no accountability from the army, so there is no point asking them to maintain the transparency and accountability. Even they can deny even that, because in the name of the national security and sovereignty of this nation, they can declare that some of the issues we cannot declare outside in the name of the transparency and accountability. So there is no special, because the act itself given enough kind of the powers to armed people through the armed people. So even the Supreme Court of India also is not in a position to control it. We can see one more case actually. It is the case of Union of India versus Ranjit Kumar Saha. It is immediately in 2013 itself, after the case of above. So this case is happening, the People's Union for Civil Liberties versus Union of India 2012, and immediately in 2013 Rajkumar Sinha versus Union of India is there. In this case, the Supreme Court dealt with the power of armed forces to arrest and detain individuals under the Armed Forces Special Provision Act. Even here also, the court only give the lip service, which means that the court says that we have to maintain the checks and balances within the law, particularly concerning about the unlawful detentions. The court again reiterated the need to oversight by the civil authorities to ensure that the rights of the citizens are not violated. Even though the court is telling all these sentences and words, this is only limited to the just on the paper. It is not directing any parliament or any state government to take any action against any armed person. The court also noted that immunity which is granted to the armed forces personnel under this act should not be used to cover up the gross human right violations. Again, here also the court says that make sure that human rights should not be violated, make sure that it should not be abusive in nature, make sure that you should have an accountability. We can agree with all those points, but my question here is, what is the status of implementation on the ground? For example, if somebody is not implementing these principles, do we have any kind of the mechanism to punish them? That is the biggest question. To be frank, the answer is no. Currently, we don't have. So, if you can see number of cases, every time the Supreme Court says that Armed Forces Special Provision Act is constitutional only. It is a constitutional. There is no unconstitutional about this act. But make sure that every time it is telling to the governments or authorities who are implementing to it, please maintain the transparency and accountability. In the name of the AFSA, taking out the basic human rights from the people of this nation is not good. So every time it is just like a lip service only, because Supreme Court also has to perform within the functions given by the Constitution of India. Because we know that in the Constitution we have three organs. We have a legislature, we have an executive, and we have a judiciary. Actually, this Armed Forces Special Provision Act was formed under the Legislative Act, which is a Parliament of Indian Parliament has enacted this. Then the judiciary has always right to check whether the provisions of the Armed Forces Special Provision Act is against to any constitutional values. Then it will check what are the constitutional values, freedom of speech and expression, whatever the fundamental rights are there. But here the question is, the central government or state government is notifying only disturbed area under the Armed Forces Special Provision Act. Only in those disturbed areas only these kind of restrictions are there. Even the Supreme Court also knows that if you are not able to control these areas under the restricted areas, they may be this kind of the potential effects will be forwarded to the next region which is located just next to those regions. So if you can see that larger picture, to protect the 80% of the people fundamental rights, it is absolutely okay to curb the few people's fundamental rights. So if we can see in that context, we may see that the provision of this act is absolutely fine. But the question here is, in those disturbed areas, what is the level of the intelligence is very much important, because based on the receiving of the intelligent information from the various sources only, the armed people or army people are going to take an action in those areas. But if the intelligence is wrong, for example, then through that intelligence operation already they performed an action. For example, they killed 10 people. Now let us assume that whatever the information they got itself, it is wrong. Then the lives of these 10 people gone, and whatever the act done by the armed forces, it is absolutely wrong. But according to the Special Provision Act, they are not punishable, or they are not allowed to produce in front of any judiciary in India. So on the whole, we can say that even though Armed Forces Special Provision Act is intended to control or is intended to curb the internal disturbances or insurgency or cross-border terrorism, the application of this act should not be politically motivated. And in the name of this act, the armed force personnel or paramilitary forces should not take control the particular area, and they should not go for human rights violations. So before taking any action, they should use the meaningful intelligence mechanism, and they have to review it, and they have to perform the action with the in a coordinated manner. Specifically with any operation should lead to the less deaths and less human rights violations rather than having more number of people to be affected in that region. If you are going to implement all these things, at least the provisions of this act may be under the consideration. But still, if you can see the key observations of the Supreme Court also, it is clearly says that this act is a constitutionally valid, but it expresses concerns about the human rights, and also it is also expresses concerns about the abusing of the power. So because in the name of the full control, the extrajudicial killings and the tortures and unlawful detentions, those are not acceptable. And also the Supreme Court clearly stated that please periodically review the status of the disturbed area, because the designation of the disturbed area only give the powers to this act actually to put that area under the Special Provision Act. So it must be reviewed periodically to assess whether the AFSA continues to be necessary in your region, or if it is not necessary, you have to remove that area from that provision of the act. So immunity of the armed forces, we cannot comment more on that, because ultimately the nation sovereignty and integrity of the nation is very much important. Security of the nation is very much important. In the name of the, if the action of the armed persons or armed people or army, if there are all the actions are done only to protect the security and integrity of this nation, whatever the acts done by them is completely justifiable. So we cannot criticize those actions. So in the current context also, very recently, 6 police station areas in Manipur, because of there is a lot of internal disturbances are there due to ongoing conflict in the Manipur, the central government again insisted Armed Forces Special Provision Act under the 6 police station areas. So that's about Armed Forces Special Provision Act.